Hello. I decided to leave my cord attire on from the big hearing yesterday. How is everybody today? Saturday. My day started early. Crafton's not here. He's at his job that doesn't exist. Um, and then I had Aiden very early. There was a record release today that I got to drive around our general area here to 4 different record stores looking for. Turns out it was like a limited 2000 release thing, like across the whole country. So had I known that, I'd been like, yeah, we should maybe call ahead to these places. So it's been a long day. You'll hear my printer in the background. That is because I am still printing out my notes. But today we are talking about the default ruling that came down this week in the defamation case against Critical K. You can put a 1 in chat if you know who Critical K is. I think a lot of people here do. I'm looking at people in chat, and I think generally it's known. So I just want to be sensitive too. I will explain some things along the way. I'm going to operate on the general sense that people know who Critical K is. Hi, Becca Chu, Boston. Welcome to membership, by the way. Crank Squirrel. Michelle. One of my shouties. I wonder what. Mod Squad. Hello, Robert's May Queen. Do I have Ray? Ray is in here. We're only missing Izzy this morning. Sugar Beet. Truth. How are you? If you guys aren't subbed over at Truth, you need to be, because the community posts have been wild. And you probably know that because I'm like, oh my God, I'm like sharing most of your community posts. Wyoming, how's your weekend going? Hi, best mods. Care D. My main shouty. Rose. Tracy, how are you? Auntie, hello. Let me see where we're at. Where is this printing going? Well, I'm going to talk about the back story before, and then I'll read you the ruling. So Critical K was a channel here. In fact, I think she termed the phrase Watts Island. So if you're not familiar with her, I'm just going to give a very broad overview. So K was a very opinionated. She still does have a channel. It's not monetized. I know she still does her Patreon. But at one point she had a very successful YouTube channel. She was featured in the Watts documentary, in a kind of lineup of online commentary clips that were played. She was prominent in that. She was kind of known for contrary opinions. Crafton does call her a contrarian. I don't know if I necessarily call her that. I mean, yeah, I guess maybe. Because, she was also very good at, she appreciated debate, okay? I'm going to also disclaim right up front. So I was friendly with Kay in the beginning. There came a point we had a little falling out, right? So I've been on both sides, so this is like nothing personal to me. I don't feel one way or the other about Kay these days. We don't speak, nothing like that. So in that regard, food just got here. I'm jealous, Michelle. I have my coffee. If you hear me sipping, it's because I got my coffee. I'm still trying to get my caffeine in me. Yes. She coined the term Wyoming. So, and by the way, she was one of the very first channels that I came across because, it's not that I didn't watch YouTube. I did. But I was definitely more the, how to, and little niche, like special interests and things like that. The true crime community came actually when Kim Kaufman showed up, is when I sort of got over into chats and stuff on true crime channels. So I was interested in the Watts case. Mainly I watched the documentary and was curious about Nicole Kessinger, which led me over to YouTube. Eventually it landed me on, don't fault me for this now, Armchair Detectives channel. Hi Squirrel, you're probably, hold on guys, give me 1 second. This is probably the one Crafton was telling you kept coming around, he couldn't find the phone. Kenneth, you're going to be out of here. Why aren't you upstairs with Boyd? Don't you want to go see your boy? No? You want to get that? I get it. Hi, baby. Okay, hold on with me. Sorry, Kenneth. I can't keep focused. I'm sorry. There's going to be a swirl. Sorry. There you go. Now I got both cats and no dog. So Kim Kaufman became the primary interest. I had questions about the legalities of some of the things that she was purporting to do. Namely, she claimed to be sort of a spokesperson on behalf of Chris Watts. And yet she had right off the gate, Kim Kaufman's channel blew up in membership. She was gifted a Facebook group that had lots of members. She had a Patreon. So we knew she was getting money in. But her stated purpose was to, get lawyers for the family, 35C, things that benefited and enriched Chris Watts. And claiming to be his personal his personal spokesperson, to me that felt, illegal. So that's what caught my interest there. And that actually, the first ever video on Kim Kaufman was over on Kay's channel, because Kay had a Facebook group on the Watts case. But what's important to note is she often would have topics where she would act as the opposing viewpoint. Put in with that somebody with a sharp tongue who could get a little, boisterous with it, right? I can respect that. But when you're talking about individuals, that can lead to some things. So fast forward to the Christian Andriaco case, which sort of became like an internet thing. Kendall Ray, who a lot of people in the true crime community are going to know, she has a very large channel, had done a show that explored, because there's controversy. Okay, so there's controversy about how the investigation was run. Officially, it was self-harm. There is a large segment of the true crime community, including the topic of Kendall Ray's show, that argued that it was actually not investigated correctly and was misclassified as murder. Okay, that it was a murder that was misclassified as a suicide. So her position was that it was self-harm. Okay, but she took an extra. She liked to play devil's advocate. That is correct, and I will say this. So, from my personal experience, at times, because she was very opinionated. Let's not mince words with that. I don't. People that don't know who she is, I don't want to blur that fact. Very opinionated. However, she would often argue just with whoever, and sometimes it would go the other way. She could argue both sides. Okay, and so it was what it was. There was statements made about Christian's mother. Her name is Ray, and just for the purpose of going forward, we're going to call her Ray and Kay. Okay. There were things said about Ray. Ray is a mental health professional. Some of those things included pointing out that, in Kay's opinion, her son did self-harm, and then bringing up a client that self-harmed. So by implication, that could be construed as a defamatory statement. It's claiming malpractice where no malpractice ever was alleged, formally. So had there been some sort of filing out there that Kay had her hands on, well, then that's not defamatory. She'd have reason to believe that that was true. There was a few other things. So, misconduct with minors, namely getting them inebriated. Bribery was one that came up a lot. in the meantime, Ray had a track record established of suing people that were critical or that spoke about the correctness of the findings of self-harm. She, I don't want to classify it as litigation happy, but but there was a track record. Okay. Everything got thrown out always. Okay. So she was not successful in these suing people for defamation leading up to Critical K. When she files on Critical K still did have her channel. Okay. Eventually she was terminated for under terms of service. Bullying and harassment is what that magic screen said when you would try to go to her channel if you have the link. Not going to comment on that. Don't know what the situation was. But at this time, it's important to remember she still did have her channel. When the lawsuit was filed, she did private most of her stuff. A lot of it moved over to Patreon. But nevertheless, it was, if you were following her and listened to her, if you were a subscriber, you would have noticed the shift. Okay. There was definitely more restrained content, less content, and all of the, I think it was all of it. And anybody else, please, because I see people in here that, in fact, we met over on Critical Case. Correct me if I'm wrong. I think she actually did private everything. It was literally starting, it would just lives would, from that point on, were all that were there. So it took a little bit of time. She fought the personal jurisdiction element of it. Now, the statements I just made are the basis of this defamation suit. Okay. Honestly, the most minimal of which was the basis of her other ones, right? So she would go after people merely for, and I'm talking about Ray, because they would strenuously do podcasts, do YouTube things, speak to papers, things like that. Backing up the official findings. Okay. If they said anything about her son as his survivor, she would do that. This one was a little different because these things were said direct on her. But those statements were the basis. Okay. So malpractice, that was, it doesn't exist. So we can have that opinion, but you have to say that, you kind of, so for instance, Kay could have said the facts, which is that a client indeed did end up committing self-harm. Her son died of self-harm according to, and she didn't even have to say that. Once it's established, now we all know free speech exists, okay? So there's a lot of things out there. There's plenty of us that, let me pick one that's not so hard. It's JFK. There's plenty of people that think that the official JFK findings are not correct. And as a society, we would probably agree that it's not good to say just because the federal government found something this way, just because a legal entity, a hospital, whatever the case may be, some entity puts something official out. That should not be the end all be all, and now it's defamation if you disagree or if you see flaws in that. Okay. But the absence of something like a medical malpractice to suddenly start asserting that. And again, this was one that they said was implied. And so at least that one too, I'll just cut to the shit, you guys. This never got to really be litigated. It never really got to be litigated. I do think there was a precedent-setting ruling in this case. And there's a cautionary little element to it in regards to if you are ever the subject of any lawsuit. But the final outcome is not it. The first point of contention is actually it, which is they started fighting over jurisdiction. Kay said they didn't have personal jurisdiction over her because she had never been to Mississippi. She didn't do business, all these things about Mississippi. The problem with that is, of course, she lost that ruling. On YouTube specifically. You mean you weren't a peasant at Memphis Long? Oh, yeah. Oh, yes. So if you know her, so the kazoo, see, I think of the before I think of peasants, but maybe that's because I'm like musically inclined. In fact, I was a little bummed out. I was still with Natasha Cooper at the time, you guys, and we would do parody panels, and I was geared up to do Kay. I actually got a kazoo off Amazon, ready to frickin' go, and then she lost her channel. And then they started fighting, and now I'm like, yeah, well, I'm gonna get them all this, so whatever. But it was like I was about to be lit with that kazoo. But yes, if contrary opinions, certain things would get you called a peasant. That's true. As in you're not, you're just common. So yes, Memphis Mama, I guess. I wouldn't call any of you peasants though. So she argued personal jurisdiction. That was the first thing. There were some problems with her filing right away. It's a matter of public record. It's not doxing or anything. So just for the record, she lives in Michigan. So we're talking, we aren't talking about even neighboring states. Okay. So there's travel involved in this now. So she made some arguments, that represented someone who's pro se. Okay. And motions went back. It came down to the fact that she had made phone calls because there's general jurisdiction and there's specific jurisdiction. This came down. So general jurisdiction is, hey, you live there. You have a residence there. Sometimes it can be a business there. General, stuff can apply even with businesses. If, for instance, they have some relevant portion or specific portion that's kind of, a chunk that is being done in that location. But in this case, we're still talking about personal jurisdiction because Kay did not have herself set up as a business. So there's my first thing right there. If you have a channel of any sort, so I think she had, again, someone can correct me if I'm wrong, maybe I think she was 16.5. She's right around that area of subs. She was not a small channel. She wasn't a small channel. At the time even, she was, one of the larger channels in this sort of Watts Island sphere. But this lawsuit was aimed at her, so there was no business that they could name. In the end, she lost the personal jurisdiction because she had contacts there. And contacts under specific jurisdiction, which is when, I don't know, so in this case, defamation, but just anything, okay, whatever the thing is, the thing happened, and there's at least minimum contacts in the jurisdiction, then you're going to be subject, chances are it's going to be ruled that you're subject to the jurisdiction. Here on YouTube, we hit live and we go live everywhere. If we have so for instance, and this is what's interesting. So this is where I'll say this was only generally alluded to and it didn't get litigated out. But there's another case, which was Toddy Westbrook and Without a Crystal Ball, where Without a Crystal Ball actually was successful in arguing the personal jurisdiction. And there were some differences. So I just wanted to point those out real quick. Without a Crystal Ball did not have sufficient business contacts in the area for what Tati was suing for. Okay. They couldn't establish things like super chats, patrons, members, etc., coming in from Ohio. If you guys are familiar at all with that sector, so Tati's kind of beauty community, she's not above the drama, but generally, the beauty community has its own drama community of people that discuss the beauty community. Okay. And Without a Crystal Ball is definitely known for that sort of the drama, yeah, my opinion of all of it doesn't matter. But the point is that there were things that were different distinctly for Kay. She had interviewed people from Mississippi. Okay. Ray had, so yes, both parties in Tati and Without a Crystal Ball had a lawyer. In this case, of course, Ray has a lawyer. We're going to talk about this too. Kay did not have a lawyer. However, there were some things that, because I had not looked at this, you guys, since a year ago. Okay. Hadn't checked in on it at all. And then all of a sudden I hear there's like a rule that says, wow, I don't even think they've gotten that far yet. Well, they didn't because this was a default. So we're going to talk about all the things. But she did end up submitting some attachments that probably weren't good for her. Kay did. One of those was an email back and forth to like a legal referral service where you can gain access to low cost attorneys. The reason she did not secure one, she claimed, was that she made she said numerous. There was a lot of vague language in this too, by the way. She made numerous contacts without reply. And that was the end of that. So whatever the case may be, she never spoke to any of these lawyers that were in this network of things that she had attained. And it sounds, and I looked it up too, it's a paid service. You know what I mean? You can get it through work. She might have still, been on Cobra, whatever the case may be. Chances are she had it through that. Don't know that for sure, but that gives you an idea of what we're talking about. We're not talking about like prepaid legal or whatever the hell they call themselves now. We're talking about these kind of networks of attorneys that'll affiliate with unions and offer their services in referring to lawyers that are signed up that'll work for you for low cost. Because cost came up a lot in this, but she did not end up getting an attorney. She was pro se. That's correct. So, well, here, let me pin that. Rose, yes. She did the whole thing pro se. So, Kay had interviewed people from Mississippi. Okay. The defamation was put live over YouTube, which is worldwide. Okay. Once somebody challenges jurisdiction, personal jurisdiction, in this case, again, keeping in mind, we're not talking about general jurisdiction. Kay didn't have a vacation house there. She's never been there. She didn't go to this person's house and yell in their face or anything face to face. So this is now moving to specific. Is there an element of any of this? Is there minimum contacts in the course of what is being alleged that links back to that jurisdiction? And the answer here became yes, because she interviewed people, she called people, she made allegations, and it could be shown that she had both members things. It was gone. Okay, so that's done. So that's ruled against her. She ends up filing an appeal, which is fine. Okay, she files an appeal. Now I need you to understand, without me going and reading all of these documents, because this last one is long enough, but well, it's not super long. It's 8 pages. Otherwise I wouldn't read it. But it sounded like tuning into her show. Okay. They were worded in such a way that had kind of this big language, this vexatious and malicious defendant. It's just things that an attorney would never put in there. Well, sugar beet, but cost isn't. So we're going to get here. Okay. So they deny that. Okay. They deny her second one. She doesn't give a lot of information. She's now, once you're doing an appeal on a ruling, while it's still going on, motion to reconsider, I mean, you have to answer to the judge's ruling. It at least has to address the reasons the judge has given. So for instance, I have 200 members, whatever, I'm picking a round number, 200 members and 200 patrons, and I have 2 in total out of 400 people that are there. That might have been something to consider. I don't think it would have worked, but that's something that could have been considered. If you lost sound, try coming out and going in. I'm just looking, my little circle's still going, so it might just be that. Anyway, not a great argument, okay? They also, so in the second, in denying her appeal, they reaffirmed their statement, said she failed to give them any adequate answer to the ruling, or new information to consider, and pointed to the fact that included in that was that there were no attachments. Okay. So she does it again with attachments. Only in the interim, they have scheduled a conference to start trying to do some mediation. She's been arguing the jurisdictional issue. Cost was major. Yes. So in that way, cost was major. That was one of the things that she she brought that up constantly throughout. But reading her documents, you guys, it sounded like her second appeal on the jurisdictional issue. Um, but I think there was a reason for that. But it's, so there were all kinds of filing issues as well. Every jurisdiction is different. This is a federal court. They would not take anything electronically. So she would have to like FedEx it and things like that. She spent a lot of time fighting rulings that existed. And then as something was very near, she'd make an argument that there's not enough time. That did work the first time. They continued. It did not work again after that. Okay. So they tell her, we'll do this conference, things like that. They allow her to do this third one. And that's because Ray's attorney agreed to it. I am telling you, this is my opinion. They agreed to it because she put attachments on it, and the attachments didn't really help her out much. In fact, the attachments tended to set things up for later arguments that I think were some of the basis, and you'll hear that when I read it out. But she was sanctioned, so that was her first sanction. Okay, the first sanction was for $100. Okay, and they said, listen, you have to participate in this. This is a mandatory conference, and you need to be here. Okay. So when that didn't fly, she got sanctioned, and then they were willing to do it via Zoom and or telephone. And she did not show up. She didn't show up. So that came another sanctions. She has been sanctioned in this case twice already. So sanctions, you guys, are punitive. They're meant to be a penalty. It's a penalty for not complying with the court that's supposed to incentivize you to comply with the court. Okay. The second one was for all of Ray and her attorney's costs in traveling to the court and being present for this conference that then Kay did not dial into. The second one, Gladys, was for $900. Just under. Okay, so it's still in the 800s, but it was like this rough amount because it was actual cost. The sanctions was, listen, they traveled. You just had to call in. You didn't call in even. So you wasted everybody's time. So these need to, these parties now need to be made whole. Her response to that was that she was not wanting to avail herself or waive the jurisdiction. But that's not legal. You know what I mean? That's not a legal thing. It's like if you've already raised the issue, you've appealed the issue's there. Now the process is that you go through the whole process, and if you don't like the outcome, it becomes a basis for an appeal. Or if you win, then that is a factor in how much the other side might have to pay, because she would have had the opportunity to ask, for costs. If she had a lawyer, she could ask for lawyer fees, things like that. So that didn't work. So personal jurisdiction is really the thing that stuck. And it came down to, in her mind, if she participated in any of this, then she was waiving that, but that is legally inaccurate. It's just legally inaccurate. If a judge rules, you guys, you have to follow that. Because, the judge is the one who's going to make these decisions. Okay. Fast forward. And as this has gone on, we've got 2 sanctions already in place. We have a refusal to acknowledge a court's decision, a federal court, by the way. This is federal. I have to stress this. This is federal court. This is not even, like me going to my courthouse and I'm going to file this, or, this is like federal court. She just sort of refused to acknowledge it. And so she was advised to get a lawyer. And that's when this happened, where we did another continuance to allow her opportunity to secure counsel. The time came when she was supposed to check in with the court. She again failed to do that. Her response to that was what we had talked about, where she was asserting that, she's trying to get a lawyer, nobody's calling her back, or whatever the case is. That was not sufficient for the judge. And off they went. Okay. They rescheduled just the sort of mediation and status conferencing and things like that. And the next time she didn't show, they filed for default. I'm going to read you the what this came down to, but I want to say this. It is unusual for them to award this kind of thing, okay? So in that way, you're not going to see very many of these. Financial sanctions are the way to go. Also, the time for her to pay those sanctions is just about here. The reason there isn't a financial award yet is because she has, this was the other thing, by the way, this was like the big one. She failed to produce discovery, you guys. So this was like the straw that broke it. She failed to produce discovery. And part of that discovery is they need to see her financials. Okay. And so think of the Murdaugh trial, you guys. And Stephen Smith, all of this, like if you're going to sue somebody, you might pick an arbitrary ballpark number, but you're not going to be subject to that. You get a discovery period where oh my God, by the way, he is amazing. And I hope he covers like what happened at the end, because his coverage along the way was like beyond, you guys. So he's like a Texas lawyer, okay? Kind of no nonsense, like everyday Joe kind of guy. Love uncivil law. And he did, I think he did a couple shows on Case, but he cracks me up. I love him. So just small little thing. If you're into like legal stuff, or if you're just interested in this case, great place to go look. But when, so failing to do discovery, failing to show up for these hearings, that's where this originated. You're going to hear that in the ruling, but they can't do that, you guys. In fact, uncivil law is a good one, you guys, if you just want some of the the two that I remember him doing, he reads Kay's legal filings and does commentary over her filings. And so that's, it's not what I want to do here, but it is. So I do recommend it if you just, if you want a taste of how she was representing herself to the court. Okay. That's the place to go. He reads them in their entirety and gives you, and he is a licensed attorney. He will tell you what he thinks along the way. And he would consider him more of a legal education channel, honestly. So it's always very interesting, the things he talks about, and it's a variety of cases, but he really does a good job at kind of explaining to the audience, kind of alternatives or what he would have done instead, how things work. He has a way of explaining it in lay terms that I super appreciate about him. Sorry, Allie, let me take a quick look here at some of the comments. Does the court take your income in account before the warning? Yes. And so if you've seen people commenting around, or if there's maybe, I think there's only like 1 or 2 videos yet about this. And sadly, Kurt wasn't one of them yet, but they want her financials. They're prepared to get them through subpoena if they have to. She's been invited to participate, but of course, the whole bottom line of all this is that she hasn't so far. She's been very obstinate, very, in my opinion, disrespectful to the court, you guys. So this isn't personal to Kay. It's merely that court is a very formal, rule-driven place that in the end, the person that you're pissing off is the one who is going to determine your fate. Now, most courts are very lenient to pro se, litigants and defendants. And she got a lot of leeway, but unfortunately, there's not a lot you can do if you are in this position where you are refusing to acknowledge the court's rulings. And procedurally, you're making missteps, such as appealing an appeal when you're still in the process and using your disagreement with the judge's ruling as your basis to not participate. And not only to not participate, to not even, because frankly, you guys, if she would have just said, fuck you guys, I'm not doing this, right? Then they probably would have taken other actions rather than let time go by and have attorney's fees racking up. The travel costs, like I said, for them between all, her legal representation. And the reason I'm saying that rather than just her lawyer, I don't know if they had to take someone else, a clerk or anything like that, a secretary, anything, right? If they had any help, it could have been two people, whatever. But, so her legal representation and Ray herself, the reason it was this 800 and odd number is because it was the actual cost that they were out of pocket, so that wouldn't have been incurred had Kay simply said, I'm not doing this, right? But instead she kind of was silent. It was a little bit of jerking him around, so that didn't play well. But I think the judge had good reason beyond that. I don't think this was a biased issue or, hey, I'm mad at you issue. It really, here's what it came down to, you guys. In the end, because there had been so many instances of her not participating in the process and sort of leading them on, if you will. That's not a legal phrasing. That's just a way to think of it. Okay. Allowing them to think that they've reached some resolution. And of course, the court figures that someone's going to file orders, especially if they've been appealed and again affirmed. It's like this. And then this is still going on. The fact that they took into any consideration her appeal on the appeal of the decision that still stood was a gift, but it's because in there were these things that were supposedly evidence that weren't really evidence. And in fact, contained in them was even more proof of the defamation. Okay. Because she started to reaffirm the defamatory statements in her filings and then attaching either corroborating statements that she found online. Essentially she was arguing gang stalking. Let's just get real with it. She was alleging that Ray and her cohorts and her affiliated, social media folks were intimidating her. Then on the other side, they were able to show that Kay was giving back just as good as she was getting. There did not seem to be a lot of intimidation. The other thing that ended up being included in the decision, literally a screenshot in the decision, you guys. Clearly along the way, Kay had a friend that wasn't really her friend. Okay. In the mix at some point, after she failed to comply with discovery, somebody turncoated and provided to Ray and her attorneys a text message exchange in which Kay clearly said she had no intention of ever going to Mississippi, period. That's bad. Yeah, it just didn't. I wonder what because again, they gave her time, right? So obviously they knew she wasn't happy with the outcome of that, but it's still binding. It's binding. And courts don't have time to educate us. And they certainly don't operate in the YouTube drama sphere. They're not in the trauma community. they're not going to sit and have a discussion with a pro se litigant about, hey, I know you don't like this, but you're still subject to it. And I trust that you're not going to disrespect this court and think that because you think you're right, that your opinion overrides my opinion as the judge of this case. Nobody's going to have that conversation. That is assumed, right? That's basic. I don't even think that's a matter of if you have a lawyer or don't have a lawyer. I think most of us would have that level of respect for a court. That's just my opinion. But the not producing discovery, that's the heart of a case like this. Excuse me. And the work that goes in to even narrowing down, like, what are you specifically looking for from the person? You know, that's the amount. This is going to be an interesting ruling, you know, in terms of the financial aspect, which has not happened yet. So it's something where I'm going to keep an eye on it because I want to know in the end what they come up with. But I have a feeling the legal cost, that's just going to be like a given. All of Ray's cost and it's all going to be a given. The lawyer's cost, all of it. This was not the way to go, for sure. And if she had access to low-cost attorneys, because not all of us have that, right? Unless you have like a union job or you have some sort of EAP program. You know, there's the, God, someone help me what it's called these days. It's not prepaid legal anymore. You know, this is because that's how it was presented, by the way. This is why you still shouldn't. This is not fair. I mean, it was like, that's pretty much what it came down to in that third one. This isn't fair. I can't get an attorney. I have access to this thing that, frankly, most of us don't have access to, that allows it to become more affordable, because it's never going to be convenient, you guys. Getting sued isn't a good thing. Okay. Having to sue someone else, not necessarily a good thing, but at least if you're the one like initiating, there's certain circumstances where likely you know, you could probably get someone on a contingency. Legal Shield. Okay, yeah, that's what I thought. So yeah, I mean, it's a pain in the ass. And if you can't afford it, that's bad. And that's all the more reason why you should be extra sweet to your judge. Okay? You should be extra compliant because you are at a disadvantage. You're at a disadvantage. So you want that judge to be understanding of the fact that you are in a pro se situation because you have to be. So demonstrating to them that you could have not been in this position and had representation, and your reasoning is nobody called me back. I mean, unless you were, that would have needed to be honed in more. That was my opinion. You need to be qualified more. So did you call 8 different attorneys, which comprised all of them that were in that region, that were on this network, and you called them how many times and you emailed them how many times? Like, you would need to be that specific for this to even fly. Because otherwise it's like, well, okay, you know, they have court, they have, I mean, she didn't even specify if she left a message. It just said multiple, which could be 2. So I don't know. Just suffice it all to say, the court was fed up. By the time this happened, the court was fed up. The discovery came and went. She didn't do it. The next thing that was filed was a motion for sanctions via default judgment. And in federal court, you guys, super rare. Super rare. Financial sanctions are where it's at. The deadline for her to pay the just under $900 is coming up in a week and it's just 8 days. And honestly, they don't sound real hopeful either, by the way. The only options that were left were jail. Okay. Jail or money. Or this. So money was dismissed out of hand. I'm going to kind of, because I'm going to end with reading it and then open it up for people that want chit chat about it. And I'll open up panel too if people want to come up. Just kind of a spoiler. They said they pointed out that financial is not going to fly. You know, just about every response she ever gave to the court expressed how it's cost prohibitive for her to even engage in the process. Now, of course, you have to understand that that was thrown out, that was dismissed out of hand in everything the judge ever said back because of two reasons. The first of which is she was offered a telephonic conference and then did not show up despite the court reassuring her, like, you will have an you can do whatever you want when this is over. You need to be in the process. And when the time comes, if you don't like the outcome, this is something you can go back and base for a review of your case. You can appeal this at the end. If you don't like how this came out and you feel like this ruling, my ruling here, and my ruling on, you requesting the motion to reconsider, they can do that. But at this point, this is the decision and we're moving forward. They made that very clear to her, that this isn't going to take away your right. It's preserved. It's on the record. The decision's on the record. Just because you don't like it doesn't mean you don't have to abide by it. But the money part wasn't working. At this point, she had $1,000 outstanding between two separate sanctions. And in total, she had yet to do anything but fight on this personal jurisdiction issue. And she couldn't say anymore. Once they corrected her that, no, this isn't subjecting you to anything. You're not waiving your rights to anything. You just have to, do this here, So here we go. So with the money part aside, it came down to jail or Ray wins by default. Those were the two options. The deciding factor, again, it's just something. In fact, hold on. Maybe let me do this real quick. This is going to be so low pro. Okay. Professionalism fail. High tech over here. Don't you know? I'm going to take a picture of my paperwork with her, with head and provided their personal correspondence to the other side are the ones that became the catalyst for this. This is just my opinion on it. I'm not sure they would have went, because this is, no judge likes their decisions overturned. Nobody does. Nobody wants that. That's a waste of court time. This is so unusual that the decision, he had to cover every single base. And like I said, seeing something that we would see on any of the drama channel, any of our little drama channels here, right? Like this screenshot of a DM message looks like it's from Facebook. Seeing it there was very out of place in this very formal court decision. But it's because it showed her intention. Literally, judge, she's going to keep dicking around. Not what they said. That's me paraphrasing. And here's evidence of it. So this person did it for her. I think they probably would have sanctioned her. They would have admonished her again and probably given her a very hefty sanction. I think there would have been one more financial sanction than they would have seen if she met the deadline coming up here on, she has to pay it by the end of the day on the 1st of May. So let me pull this up. And I'm going to have this up while I read you the document here. And then we'll talk about it. I think along the way, there were plenty of opportunities, frankly, that if she had representation, she probably could have won this, right? When people see me talking about the precedents this set, It has everything to do with the jurisdictional issue when it comes to YouTube creators. Because that's a big deal. Okay. So when we're going live across the world, it's a worldwide platform. Okay. We might not have viewers in every country, in every city, in every state, you know, depending on how big you are. But the point is that we are availing ourselves to a lot of jurisdictions. And all we need then is that one minimal contact. And this ruling inside of this otherwise kind of story of someone who just sort of shirked off the process. Let's see, she got good legal advice when this all came down in the first place. Yeah, and well, I have to think that she has contacts and things like that. I don't know, and I don't know for sure, Sabrina, but here, let me tell you guys, there, law schools, if you're in an area where there's a law school, there's legal clinics. Okay. You can also take advantage of free consultations, because you can do those with as many lawyers as you want, by the way. So if you are industrious that way, you can use your free consultations here, there, everywhere, as many times as you want, with different lawyers. If you run into things that you need to clarify along the way, there's ways to do this. Doing it with no legal advice or understanding, I will tell you again, I don't want to get into it here. Maybe once I start going live over on my new channel, it might be something we can do is pick through some of her filings along the way. But I think if you go to uncivil law and go to the one, not the one from when it first started, which I think was a year ago, but there's one that he did in between, 6 months, 5 months, 4 months ago. That's great. If you just want a taste of the way Kay was wording the things she was sending, she was warned every time too about not using even the legal formatting. She wasn't using the ruled paper. It's crazy. Are you duly streaming? No, just this one. No, we figured that out when we did the simulcast last time. It's a little bit. Yes, and sugar beet, truly, it takes a lot of legwork. It's not fun, you guys. Being sued's not fun. But like taxes aren't fun, but we also have to do it. If somebody's suing you, you're dealing with deadlines, you're dealing with rules that you're not going to be familiar with. It's why people hire lawyers, and it's why lawyers make what they make. And it's just not an option. It's not an option. Okay, here, let me go. Okay, let me pull this up, you guys, because you have to see this. Because this is the one part too that I'm like, ooh, here's the little drama community stuff that ended up factoring into this. It's like she had someone in her midst that she just could not trust or should not have trusted. And I don't know who the person is. This could have been in a Discord for all I know. I have no idea. You guys might know. This is partly why I'm like, here, let me pull this up. It's not like super high res or anything, because I just took a picture of it from the legal decision itself, because I have it printed out. Here we go. I love when I send myself stuff, you guys, into Gmail. It tells me that this message seems dangerous. Do you trust this sender? I'm like, well, I hope so. Okay, here it comes. Let me see. Okay. All right, here we go. Let me get this out of the way. Oh, it says Taylor. So that's probably whoever this is. I don't know who that is, you guys. So you can only see part of it. So the court threatened to sanction me again. So this is after the 100, but before the almost 900. Okay. So yeah, last time they sanctioned me 100. Who knows what they'll do this time? But I'm not going there, period. Ever, period. It's just not even possible. just something that benign when you are in the midst of a court proceeding. Yes, I will definitely do that, Boston. Hold on. Because it pertains to something that we both are thinking of, I'm sure. Crafton doesn't even, he does, taxes are so inconsequential to him because he doesn't have to do them. I had to file an extension, by the way, you guys. I spent that whole day. That's my fault for procrastinating, but I'm like, no, mine was like easy peasy. And that's even with the 1099 and all that. But it's like, got to he's got like 8 different places. He's getting royalties and then he's got 2 channels. And I was like, oh my God. And we're married now. So I'm like, yeah, your funky taxes are my funky taxes. But a lawsuit's a lot like taxes. You like have to do it. So that last one is kind of what matters, okay? But I'm not going there. So they'd already ruled. Then they were willing to let her do like these kind of mediations. They'd already decided she could do that via phone. Now keep in mind, she never did. She was a no-show to those 2. I mean, she undermined every one of the things along the way. I have to imagine this court was just so frustrated with her. But that last one down there is the one that mattered. Let's see here. Did I get myself out of order? Where's my first page? I'm going to have the first page of this, you guys. Hold on. Where's my caption page? Oh my goodness. I might have not. So I might have to start this kind of after all the caption stuff. So, okay. So I will start from history, you guys. And all I'm missing here is the caption. So no discovery. Okay. In August of 2021. So every time it says Yaks, you guys, that they're talking about critical K. In August of 2021, Yaks moved to have a fast approaching settlement conference conducted by telephone or video. Docket 41. The magistrate judge denied the request, but postponed the settlement conference to allow Yaks additional time to make travel arrangements. Docket 43. The magistrate judge further ordered the parties to confer and select a mutually agreeable date to hold the conference in person. Andriakos says Yaks refused to comply with the court order to confer and to pick a date for the settlement conference. And then so I'll quit reading unless do you guys want me to say the docket numbers? You guys, this is all available, by the way, if you go to Mississippi courts. It's federal court. You can go over there. I'm waiting just to see. Yes, they had already ruled that. Okay. And the reason, okay, so here's the other thing, you guys. You will hear, okay, so for instance, let's take Lana's case, right? She was allowed, it depends on the jurisdiction and each court operates differently. Sadly, there's not like a standard uniform way of doing things that covers, things court to court. So federal court, it's not unusual for them to require in-person appearances. Some places had little exceptions during COVID, but, some of those have ended. Some of them have always kind of been, more lax. The one thing that's more common is that they'll allow electronic filing. Federal courts don't take you have to request electronic filing and it's rarely given. But to my knowledge, she never even asked for it. Okay. So refused to comply with the court's order to confer and pick a date for the settlement conference. So what they said is you're allowed to do this over the phone. Okay. You're allowed to make some initial conversation and essentially we're going to allow you, okay, to pick for us within this time frame. We're going to push it out to allow you to figure out travel, but you need to partake in this settlement conference, and part of it is going to be scheduling your in-person. Part of it is going to be scheduling your in-person. 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 Scheduling mediation. Okay. On September 1st of 2022, the magistrate ordered the settlement conference for October 18th, 2022. See notice of hearing for September 1st. Yax was directed to appear in person. A text-only order dated October 14th repeated this instruction. Yax, however, ultimately failed to appear. See minutes entry October 18th. So in there, which now that I'm looking, maybe I will cover this again over on the other channel, because I kind of want to pull some of these exhibits now that I'm reading this again, for more than just the information in it. But I'm like, I guess that would be kind of interesting. I would be interested in hearing that. So that means that it probably was more than a lawyer. They brought probably a legal secretary, somebody who was taking minutes of that meeting that she never called into. Andriaco subsequently moved for sanctions pursuant to Rule 16F for Yax's failure to attend the settlement conference, docket 44, and filed the present motion for default judgment under Rule 16F, 16F, and then 37B2A6, and then these were dockets 45 and 46 for those that have any intention of looking it up after the fact. The docket 46 and 45 and 46, by the way, that is the discovery motion. And then compiled within the two, like I said, was these were part of the same thing, you got. Okay, so this was part of the same thing, which is the settlement conferencing, mediation, if you will. They were going to allow once via phone, and that was to both start that process and reduce costs to Kay, and that she could have this spread across two. There needed to be an in-person, but rather than turning to a 2-day mediation or whatever, she literally could start that process with them, set a date, that worked for her. But they sat there. They showed up, they sat there, waited for her to call in. She never did. That's what they're saying there. In her brief seeking default judgment, Andriaco notes 3 instances in which Yax disobeyed the court's orders. The failure to dial in to the case management conference, the failure to confer with the plaintiff's attorneys regarding settlement conference scheduling, and the failure to attend the in-person settlement conference. So that October date, yes. So Rose, as far as I remember, and he might have done some in between, but there's one, and it was, so he had covered it once, and it was like the next update. I want to say it was like 5 months ago, somewhere in there. Okay. So the October date, you guys, what I was saying is the October date was selected without her input. She waived her right by not calling in, by not making a phone. That phone call, you guys, is free. Okay. The phone call's free. She didn't do it. So that's why when people say, the cost it was cost prohibitive, they're probably right. They're right in that. But there were things that the court had to base this on that showed that this was intention stagnation, that there was decision making that went into this, and it was not merely a cost issue. Okay. And this is one of those things. When she failed to even call in to participate in the selection of a date, one got assigned to her. And then the time came, she didn't show up, Andriaco argues that Yax's failure to appear was deliberate, as Yax had apparently sent the magistrate judge a September 1st, 2022 email explaining that Yax was unprepared to oh shit, I forgot this part, you guys. So not only did she didn't call in, but here they're quoting. So just so you know, rather than call, she's pro se, so she's representing herself. Okay. So as a pro se defendant, she was supposed to call the other person's attorney. Rather than doing that, the day of, she emails the judge, and this is what they're quoting. She emailed explaining that she was unprepared to validate long arm jurisdiction by traveling to the state of Mississippi and subjecting myself to a process I am woefully ill-equipped to defend myself against this bogus suit designed to harass, intimidate, and terrify me. So that is a little taste for you guys of what all of the paperwork ever from her looked like in that email quote. But you see there again, she's mentioning the long. This has been ruled on already. Not once, but twice. Okay. At this particular junction. Well, no, the third might have been there too. Either way, they've exhausted any chance that this is an issue. So she essentially emails the judge with that sort of language. I'm going to read it again, that she was unprepared to validate long arm jurisdiction. Shouldn't have to validate it. It is valid. Me now moving forward, I'm under the rule of that court. It's wrong here. Okay. This isn't critical thinking. This is stubborn thinking that is self-defeating. Okay. Unprepared to validate long arm jurisdiction by traveling to the state of Mississippi. So that's just a wrong statement anyway. And subjecting myself to a process I am woefully ill-equipped to defend myself against. There's a missing punctuation here, so I'll just respond to that one, assuming that was the sentence. So they argued, the jurisdiction issue had nothing to do with the cost of an attorney, but that they were willing, they'd work with her as a pro se, so her bringing it up again doesn't change things that have already been addressed. And saying she's woefully ill-equipped. Well, the legal system is designed for lawyers. Your ability, it sucks, and it's a whole different show, you guys. Sadly, the people that have a bunch of money, okay, the Robert Dursts of the world, are able to hire Dick DeGuerin and a whole team, no matter what jurisdiction he's in. And if you're the person that's suing him, it's the reason he doesn't get sued. He didn't get sued very often. You know what I mean? So it's like, yes, it's true. Any of us would be woefully not prepared. But again, you have to at least show that you're putting your best effort for it. And chances are I'm sorry, I just read Kurt there. The judge, not Kurt, is going to be far more willing, to be lenient with you and to help you out and understanding that you are in a system that you're not really prepared for. But she just didn't do that. So then there's not this new sentence, but it is. So she's asserting that this is a bogus suit designed to harass, intimidate, and terrify me. You can say those things, but you have to prove them. And in order to prove them, you at least you don't just get to tell the court that. This is what she would have had an opportunity to try to show. This is a legal conclusion here. And so just the quoted portion actually in this is good enough to show you what the problem was for the court the whole time. Docket number 42 at 2, Andriaco adds that on October 18th, 2022, at 10:28 a.m., mere minutes before the magistrate judge was set to begin the settlement conference, Yax texted a third party the following. And that is what you see on your screen. Okay. And this is where it appears like a sore thumb, just fucking sticks out in the middle of this very proper legal document, is just this text message thing. Okay. And then it refers back to docket 44.1. For these reasons, Andriaco seeks a default judgment under Rule 16 and 37. In a response brief opposing sanctions, Yax argues that her absence from the settlement conference was due to, quote, economic constraints, lack of access to reasonable legal counsel, and then they put some dots, so they're going to a different section to continue the quote, a legal fear for her physical safety, a legitimate fear for her physical safety, mental health, and well-being, and then it would have gone on from there because we got some dots. In reply, Andriaco contends that Yax, quote unquote, poverty is very much in doubt, end quote, observing that Yax mailed her original motion to dismiss from Honolulu, Hawaii. This is kind of known. I've heard this talked about. I feel like Kurt probably did mention this because I feel like I knew about this. I don't care. I don't need to know her family's travel, whatever the travel was for. It just doesn't look good. If you live in Michigan, you have and there is a Hawaii, when we think Hawaii, we're thinking the palm trees, the resorts, all that stuff. It's not a good mental image. Okay. It's not a good mental image when you are saying, you're making these sort of excuses, which can excuse certain portions that are required of you when you're in this process. But it does it marginalize them a little bit? Mm-hmm. Yeah, it does. On February 1st, 2023, the undersigned scheduled a motions hearing for March 20th of 2023. The scheduling order specifically noted the following. The defendant is reassured that she will not waive. Okay, so they're fucking telling her this again, you guys. So just in March, end of March, they reschedule again. They do another schedule and make sure to put in it so this is the third time now I can count that they have continued to give her legal advice, right? Specifically noted to her the following, March 20th, 2023, quote, the defendant is reassured that she will not waive her personal jurisdiction defense merely by appearing for the hearing in this case. She's already preserved her jurisdictional defense. She's not that dumb. And $95.67. That sum is due to the clerk of courts on or before May 1st of 2023. On March 20th, Yax, in fact, did not appear at the motions hearing before the undersigned. The court denied Yax's outstanding motion as abandoned and pledged to rule on the outstanding motion for default judgment in due course. So she actually took the time to file. She had filings that were still in. Wow. And that they're considered abandoned. If you don't show up to the hearing, that those are going to be heard at. That's baffling to me, you guys. I didn't catch that the first time I read it. It says Yax's outstanding motions are denied as abandoned. So she had outstanding motions that would have been part of that hearing. Wow. Okay. All right. I'm going to read you guys the law. So we're going into the law now. Applicable law. Rule 16F states that a court may impose sanctions, including those authorized by Rule 37B to A to 7, if a party or its attorney fails to appear at a scheduling or other pretrial conference or fails to obey a scheduling or other pretrial order. And there's another caption, all the same numbers. In turn, this allows the court to render a default judgment against the disobedient party. Although there are instances where a district court awards default judgment as a discovery sanction, two criteria must be met. First, the penalized party's discovery violation must be willful. Okay, so number one, willful. Also, the drastic measure is only to be employed where a lesser sanction would not substantially achieve desired deterrent effect. Okay, so the goal is comply with the fucking court. Okay, so that's rule number two. You have to go with the least punitive, and make an argument in the ruling for the judge of why this is the minimum penalty that this court, in its experience so far, believes is going to make her do this thing. The reviewing court may also consider whether the discovery violation prejudiced the opposing party's preparation for trial. Okay, so there's number three. So when they say prejudice the opposite party, it means did it put them out in some way? Okay. Did it put them at a disadvantage in some way? So we can already answer that, right? Because this is another thing that she didn't show up to. So at least financially, she's disadvantaged them. And when we're talking discovery, right? Is it going? Are they at a disadvantage if somebody didn't give them any discovery? Yes, that's just an easy one. We can throw that one out now. That's been met. And whether the client was blameless in the violation. Okay, so that's where, are we looking for? Did they somehow interfere? The most popular, the most common thing. This is honestly, if you've ever had any sort of legal proceeding and you get freaking annoyed because two attorneys, right? Your attorney and the other person's attorney, they are constantly rescheduled. The other person's like, oh, I have a golf tournament that weekend. Anyway, you can reschedule that for blah, 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 blah. Okay. It's not that they clearly are good old boys that have drinks together on the weekend, or they're trying to disadvantage you, or like, hey, you're supposed to work for me. That's common that people feel that way. But no, the reason is because if this person has let you know they're not going to be available, if you are to say, hell no, I'm not going to reschedule this, you now have played a part. Okay. So that's why attorneys are so willing to work with each other's schedule, because that's the only way you can do it. You're not going to get any penalties otherwise. So that's not the case here. Okay. You can infer from that there was no communication. Nobody asked for additional, a different date, or said, hey, we're not available. You give a citation. Default judgment is a litigation ending sanction. Okay. It means the end of it. And under the litigation ending sanction line of cases, the Fifth Circuit has reframed the standard brackets and quotation marks admitted because default judgment is an extraordinary penalty. The court will utilize the latter articulation as it represents the more difficult legal standard. What that all means, you guys, is this particular federal court has not had a God. Get ready for it, guys. It means they don't have a precedent case in their jurisdiction. So they get to cherry pick from these two that I just talked to. One of them was a federal law. One of them was a Mississippi law. Okay. That's what that means. Think that through for a minute, you guys. It means we've never been in this position before where we're actually thinking or looking at a default summary judgment based entirely off of the process in just status and just scheduling conferences and failure to produce discovery. It's not happened before. Okay. I just want to make that so clear. So now we're getting into the discussion. So here's the gossip, you guys. In this case, the plaintiff has demonstrated all four elements of the, okay, so I tried to kind of explain that to you as we were going through because I remembered that was the standard they used. First, Yax has repeatedly violated court orders by failing to participate in even telephonic but also in-person hearings. These violations have been known and willful, and they italicized willful, okay? Did any of you watch Emily Baker? So she she'll make comments like, this is how the lawyers throw shade. This is how the court throws shade. This is how the person writing the opinion throws some shade. There's certain things. If you work in business and you have to do like correspondence over email, let's say you've said something to someone twice and they email you again, right? To me, I think of this in my line of work as, when somebody's asking me something for the fourth time and I've emailed them each and every time, I'm like, as previously stated, right? That's how it starts. Okay. And so it's a dig. It's a dig, even though it's a professional dig. That's italicizing. That's throwing shade. They have stressed the word willful, okay, with just their mere italicization. That's what happens in these kind of things. So, this judge affirms the finding of willfulness in this default judgment case, where sanctioned party. Okay, no, this is precedent setting, out of their jurisdiction, by the way, but precedent setting. Although Yax acknowledges that her presence would be, quote, beneficial to the court in adjudicating this unfortunate matter, she at the same time texted a third party explaining that she will not come to Mississippi for this case, quote, ever, unquote. I just want to let that sink in for a minute, guys. Whoever this Taylor person is, depending on what you feel about this particular case, is either a hero or fucked her over. Because she emailed, rather than show up, okay, she wasn't in the area right before it's supposed to start from Michigan or wherever she was. She emails this Mississippi magistrate with lengthy reasoning, but they found that the times overlapped with the text message that's on your screen. How about them apples? I don't get it. Docket number 45 at 2, despite the undersigned's order reassuring Yax she would not forfeit her personal jurisdiction defense by appearing for motions hearing, she failed to attend that too. And while Yax protests that she lacks funding to participate in this litigation, the facts have demonstrated otherwise, and she has failed to produce financial discovery. Second, because Yax is proceeding pro se, there is no question that she, and not an attorney, is the one solely responsible for her conduct. Next, there is ample record evidence that Yax's failure to appear have prejudiced the opposing party every time that the plaintiff and her attorney have traveled to Jackson for a hearing. They incur nearly $900 in expenses. When she plays this game of Lucy and the football, therefore, Yax is running up her opponent's bill. Lucy and the football. Anyway, whatever that means. That is the definition of prejudice. Finding prejudice. Okay. United States versus McCullen. And that is in their jurisdiction. So I'm going to go ahead and read that one out, which says that finding prejudicial the resources that the plaintiff had to spend in responding to the defendant's numerous rambling filings. Well, okay. Lastly, a lesser sanction would not substantially achieve Yax's participation in this lawsuit. They cite a case. Called the 49,000 currency case that rejected a proposition that the district courts are required to attempt to coax a claimant's appellants into a compliance with their orders by imposing incrementally increasing sanctions. Okay, so they're saying you have to show some demonstrated evidence that you have, because there's that the least thing that gets them to do whatever the thing is, okay? So here they're going to explain what those are. Warnings, show cause orders, each have borne no fruit. If Yax lacks resources, a third award of monetary sanctions would be pointless. This is where the court held all of her arguments about money against her. Okay. If she lacks resources, then why do another monetary? That's totally right. Leaving incarceration. Incarceration, meanwhile, the court finds would likely be too severe a granting this order or putting her in jail. These were the options she had left for them. Offered to this defendant. So this is the cover their ass penalty. Like, this like, listen, I don't want you to overturn my shit because I just did something so rare that it's, so is it muted, you guys? Hold on. I have my son home today and I'm wondering if that's part of this. Hold on. Let me see if I can find. Say what's up. Put a 1 in chat if you can still hear me, you guys. I'm going to text my son and make sure he's not on 80 devices. Hold on. I'm not talking, you guys, while I'm texting. This is ADD at its finest. Okay, you guys can still hear me good. So this is because, it is spelled out so much. And they are qualifying this so big because it is just so rare. Okay. For these reasons, and on the record, this rare sanction of default judgment is warranted. In conclusion, Andriaco's motion for default judgment is granted. An evidentiary hearing is necessary to determine an appropriate amount of damages. One will be scheduled shortly. Yax is invited to participate. So ordered on this 19th day of April 2023. U.S. District Judge Carlton W. Reeves. Dun dun. Okay. Neat. There it is. I'm in and out. Yeah. I just turned off the TV. It should be, but okay. Yeah. No, he's like, yeah, he has. I'm like, do you have multiple devices going? He's like, oh, my Switch is still on. Oh, wait. And I'm on my laptop and my phone, but I just turned the TV off. So he was streaming, streaming TV while playing video games with his phone on Wi-Fi. And yeah. Let me real quick, you guys, I'm going to make sure that the upstairs TV isn't streaming. Right. So PB&J, she did not have a great record before. Okay. So the basis, and like I said, we'll never know. Here's the lost part. We'll never freaking know here because the basis for a lot of Ray's lawsuits prior had been things that were said about Christian and her unwillingness to accept whether that's right or wrong. I'm not going to put my opinion in on the case. Okay. But whether it's correct or whether it's incorrect, she based a lot of it on her own, on the premise that it was defamatory to him for the people that agreed with the ultimate findings, the official findings. It was streaming. So we had 2 different streamings. Give me a second, you guys, to see if this betters our situation here. Yeah, that's not good. So we had streaming going on because I stream a playlist I have of Bracket Gaming, trying to help him get his watch hours. So that was still going on upstairs. And then Aiden with his many things. Okay, cool. Looks like I'm seeing more bars. Is that any better, you guys? You can hear me? Yeah, so they have to, to a certain degree. Okay. So to a certain degree, Boston, because and they noted it in here, and so that's how we know. So the one sanctions for not showing up, that was the 897 and some change. They've rounded up in the court, indicating and kind of that's like a nod to her, by the way, that hey, every time you've done this, it costs them $900. So actual damages can be awarded. And this is going to be considered actual damages on that part. That's without considering the defamation. I mean, whatever it costs them to do this, now she's on the hook for. That's just a matter of truth. And you don't have to be able to pay for it to be awarded. It's not going to go by her net worth, but they want the court, and especially Ray's lawyers, are going to want to see that. And keep in mind, they've already asked for that, and it wasn't provided. They want to see that because they want to know what's realistic. For instance, one of the things she kept asserting over and over was bribery. One of the things, God, do I want to go down this rabbit hole? Let me put the link in chat in case anyone wants to come up, or if this statement causes people to want to discuss a little bit. Okay. One of the things that she constantly would reference is this notion of Ray and bribery. The bribery element was that they were willing to negotiate with her because she had indicated that she had some inside information that Ray was interested in. And in essence, they were willing to do some negotiating on any sort of financial level in exchange for this information that Kay claimed to have. Well, there came a point where Kay flat said, I mean, she was saying this in her effort, and this was one of those, pieces of evidence that she attached that I told you about that was did not work in her favor. But in it was her responding to some other channel's comment section where she was asserting that she doesn't have any special information. So what she just did is yank off the table this thing where they were willing to think about, hey, okay, so you say you're broke, so that's cool. Maybe instead of this, we can work out a settlement where we drop this. We don't want money. I mean, what they would have done is they would have wanted the information. They probably still would have asked for the costs, and there would have been some other sort of like NDA-ish kind of, you're not going to talk about this again sort of thing. My opinion, it's probably what it looked like. As soon as she let it out of the bag that she didn't have that, she lost all her bargaining chips. My assumption is that she must, for this person to have the idea that she had that, there had to have been maybe something said. But how many times do people come on here and act like they have information they don't have? You know what I mean? So something happened at some point. I don't know what to believe. I don't know what's true. I want to say maybe she didn't have any information, because otherwise wouldn't any of us be like, willing to, if we had done a bunch of research on a case and had spoken to people that were, semi-involved, peripherally involved, whatever. If we had, she had done some things that got records from the investigation, things like that. But just this mom knowing that she had talked to certain people and had a friendly position with those people, her thought that Kay had obtained some information to me probably came from Kay. But she's calling that bribing. It can't be bribing if you are in the middle of a lawsuit. That is an invitation to settle. I mean, that's negotiating. But she continued to call that bribery and submitted it, saying that was, evidence of bribery. That's how we know that that's what she was considering bribery. It's crazy. Yes, I think that you are so right. You know what I mean? I think so too, because the other thing is that, it's a done deal now. It's a done deal. $900 every time these people had to convene and she didn't show up. Okay. I think that my bets would be that we can just bank on her having to pay legal fees. Okay. So not just for these missed things and things that she caused with not showing up and not participating in the process. I think she's going to have to pay the legal fees. And then now we're looking at what kind of punitive damages we're looking at. What kind of, how are they going to value the defamation? Because now that's what it is. So the default part, yeah, that's important. I can see why, she, for instance, and why us as outsiders would want to keep that in mind, because we're sort of deprived any sort of arguments on both sides. This was almost a giveaway. So there's going to be a lot of interesting things when they do this hearing, because she didn't comply with discovery. When they say it's a little shady, I mean, it's a little curt, it's like, I get the little sauciness, and it's like, we've invited her to participate. I mean, they don't anticipate she's going to. I mean, they're going to end up making a ruling probably without, and that is weird to me too. So listen, you guys, YouTube, you're going to need to be like a big ass channel that gets a lot of views, where you're pulling in some of that ad revenue. You're going to have some sort of side hustle, whether it's merch, whether it's Patreon. This is not, you have to get to a certain level before this is like a place to make, bank, if you will. Okay. I don't know why she wouldn't want to show her financials, but especially now, you know what I mean? Show it now. I mean, if you are not in a good position financially, now's the time to show it, because she is risking them doing this without ever having seen that. And that's something that they will at least consider. It's not going to dictate anything, but it's something that goes under advisement. It's something where then what Ray's attorneys voices what they would like in this hearing could in some way consider that, right? Now they might get a little more creative, but at this point she's flat said, I don't have any other information. So I don't know what other bargaining chips there are out there other than money. But of course they seem to be aware that money might not be something that comes in. It's going to depend too on if she has sanctions. She still has to catch up. I mean, she's not in a good place. Yeah. And again, it's not really, so I want to make this very clear. Okay. So let's say I'm a millionaire, right? Not, not the case. We're being hypothetical. Let's say Rose is a millionaire. Rose, I'm going to make you a millionaire. Okay. You must show me. So Rose is a millionaire. Okay. And I'm suing her for defamation. And it's based on my YouTube channel. Okay. It's my YouTube rep. It's my YouTube rep on my 1,300 sub channel. Okay. Where my videos make 50 cents in ad revenue ever, right? Okay. So let's say that, right? So if I spend thousands upon thousands of dollars to sue her and I win, no matter if it's a default or not, listen, I'm going to get my thousands and thousands of dollars. That's going to be ordered. Okay. And just because she doesn't have money doesn't mean they're not going to get their money. They will attach themselves to tax returns. That's going to happen. She's going to have issues. And this is my suspicion. This is my, forecasting. They are going to subpoena her shit. There is a portion of live streaming that is a cash business. That's just a fact. Okay. I know that because all last year, my spouse streamed on 2 different channels. It's not hard for me to enter a 1099 that comes from Google, which comprises his memberships and his whatever. What's hard is when I start looking at the tipping. So they're not even just going to go. I mean, I'm sure of it. They aren't just going to go for her tax records. They're going to go for her bank records. And that's going to include PayPal, Cashapp, and whatever she has. Google Pay, Apple Pay, throw it in there. If she thinks that people haven't been paying attention, there's no way. Now, it's not Natasha Cooper style. People aren't watching her channel 24/7. A lawyer isn't sitting there watching that. But they are going to have someone on their staff or Ray is going to, it doesn't have to be someone like that. This is a way you can cut down your own legal costs, by the way. If you have somebody who's willing to do those kind of things and document those kind of things, people will have been, as I'm guarantee someone's probably in her Patreon. People are waiting, they're looking to see if she's going to say more things. Things like not giving your financials over for discovery means that suddenly you're going to have a lot of, there's a lot of avenues people can take. But when you're public like this, sure. Yeah, they have somebody who would have been watching and trying to see if, how many people roughly are here or there, how many people are coming this way. What the fuck? Let me see. What the fuck would CK not have an attorney prior to starting her channel? Well, I mean, you don't see, it's not unusual. It's not unusual. Now, here's the thing that I'm like, people better do this. And I said this to Kraft, and so I'm like, we've already done it for this year, just not in time for it to have mattered last year, but we're married now, so that's different. So it's like, we have a company. We have a company, our channels fall under that umbrella, and it keeps us legally indemnified to a certain degree. That's a reason why you form a business, even if it's just you and you have no employees, right? That never happened. So that's the other thing that's going to suck for her, is her husband's income will be relevant if she's still married. And even if she's not, they're going to look at any sort of income. So if she's getting income, alimony, anything like that, this is all, I mean, it's just, she cannot evade this either, because they will just get a subpoena. And I have a feeling, listen, how many times has Ray tried to sue people and gotten nowhere? Oh no, she got handed a gift on this one. I have a feeling they're going to go all the way with it. And those lawyers want to get paid. They will attach themselves to bank, to incomes, they'll garnish, but definitely at the minimum, they're going to go for the taxes. They're going to go for any tax returns. Just going through, you guys. Sorry. If you have asked questions or said anything and I missed it, again, my ADD, sometimes I get talking and then or I'll start reading and suddenly my sentence is going to incorporate a word that I just read. So if I miss something and you want to say something, go ahead and you can put it back in chat. Again, if you want to come up on panel, more than welcome to. Yes, welcome, Cindy. Hi, Outlander, by the way. I wonder what. Let's see. She was, what? I was in a Signal chat and she was off to just so many. Yeah, she has like a reputation here. And you know what's funny? Because Crafton had to go to work. I have a feeling this would have been an interesting one for him to be here chiming in on too. Because he had more interaction with Kay, in the first few months of his channel kind of growing than I ever had with Kay. And he had opinions about her, you know what I mean? I think he appreciated that she was like a strong woman. I mean, he's the kind that he has an appreciation for that. But, there were some things, some idiosyncrasies that were interesting to him. Was she nice to anybody? Now I see what people were referring to. She was nice to Lewis. Was she ever mean to LeDuc that I missed, you guys? I don't know. Hi, Nina. Before all this, CK always says you're dumb if you don't get in a trial. Oh, interesting. Sorry. That's ironic. That's great. That's great. Well, I don't know if you were here before, but one of the pieces of paper that she submitted to the judge trying to make this case about that was not based on anything legal, by the way, on why essentially the moral of the story was like, hey, judge, I know you ruled, but it's still unfair that I should have to do this jurisdictional thing because I am so not prepared, was to submit to him an email with this like union-based like legal network. So essentially she's part of a union, or she had been and still, whatever it is. It's like an EAP sort of thing through employment, only this was for a union where she has access to low-cost attorneys. And it showed that she had obtained that list and had access to low-cost attorneys. And she said she had reached out multiple times and no one ever called her back. That was her reason why she didn't get legal counsel. And so, of course, the court had thoughts on that. Well, and I wonder what this might have been a different conversation had the legal process gone on. Even if she had merely just complied with, like, respected a court order. It's like this abstinence of I'm not going to accept what you said, even though you ruled, and yes, I'm subject to this jurisdiction. I did a motion to reconsider. You reconsidered, and you reaffirmed that I'm subject to this jurisdiction. She'd never, ever left that. Twice after that, they're pretty much giving her a little legal education in making sure to say to her, you're not giving up. You're preserved. You're on the record. You have to keep going. But at some point, if you want to appeal, if you don't like how this turns out, they couldn't get her to understand that. She just absolutely refused to. If I was going to cover true crime, I'd have an attorney review. I think, yeah. Or have insurance, make sure. Okay, so here's the thing. For me, number one was making sure that we're under an umbrella of a business. Number two, get insurance or have a lawyer on retainer. I think that's the smartest thing to do, especially in true crime cases. You're going to run into these kind of things, but just in general. I don't know if I ever want to go back to cover any of these kind of bigger creators and the legal battles they've gotten into, but it's like, that's why people like Toddy, keep a lawyer on retainer. I wouldn't be surprised to find out if Without a Crystal Ball now has some sort of legal service that she keeps in her back pocket. Yes. Speak your truth so you know. It doesn't have, people think things like S Corp this or, whatever, LLC that, no, that has to do about how, you don't need to have a bunch of people. It's not for just big business. It's literally a legal structure that can protect you if you are running a business. Let's see, Sabrina, PB&J, that blew my mind that she didn't have an LLC. Yes, that is so, it's just bad, you guys. But here's the other thing. Geez, any wonder why me personally, it was like Order of Ops 1, right? And that's just before we even got our channels back. Okay. I made sure the Mediocratics, which is the brand channel and everything falls underneath that. It has a radio station. All of our channels are part of that brand linked in the Google system as underneath that brand. If you are controversial, you better, because it can happen at any time. And that's minimum. All right. So maybe don't have any sort of insurance. Maybe don't keep a lawyer on retainer if that's not something you feel you need, or if you just have a family guy or whatever. But at least do that, because you just never know around here. If you are an opinionated or divisive person, chances are at some point in your YouTube career, if you make it very long, it's going to happen. Yeah. She didn't show. Interesting. Well, that would be interesting too, huh? See, I don't know a lot about that other than in reviewing sort of a couple articles, things like that. It seemed to me that everything she was doing somehow incorporated her disagreement and citing defamation as the survivor of Christian. It seemed like it was far more. This was the one that most directly went at her, far more firsthand. Yeah, you can't say things as fact, I swear. Aunties. How's your weekend going, Auntie? Been drama filled already, huh? Last night was interesting. You guys, I'm probably gonna go live when we're done here, by the way. I just got a couple drama things to fill in. Yeah, she was mean. Yeah, I know, yeah. I agree with that statement. I watched her a few times, but I couldn't handle. Here she talked to me. Yeah, no, she was very condescending. That's my assessment. Rapping dog. Well, yeah, I'll tell you this. Crafton didn't appreciate how the way he would put it is she went from talking to him as kind of another creator and not a friend, but a business acquaintance, to talking to him like he was an employee. I mean, he was way annoyed with her very quickly. And for me, I just couldn't. I mean, that, two alpha chicks together, that just doesn't ever work. You know what I mean? I need to do cleaning today. Willful ignorance. Do you think? I wonder what? You guys, because I will say this, no matter what I think of her otherwise, she's not a stupid person. It's like all of a sudden she doesn't know what, that a court order is binding, even if you don't agree with it. I don't know. The fact that she couldn't get it through her head that it does not work to just be like, I'm not doing it. I don't know how she thought it was going to come out any other way. To be sanctioned. Now, I will tell you, I've left this stupid thing up on screen, you guys, because whoever this is, like I said, depending on what side of it you're on, this is the hero, or this is the person who fucked her over, depending on what side you're on. This ended, just the fact that one screenshot from one person who turned on her in some way or leaked information the other side, whatever it was, right? I don't know. I have no inside information, none. Don't know who this person is, no clue. This ended up being such a huge part of why they did this, because they're like, no, she has given her intent, that she has said it. I'm not going there ever. Hey, Sarah. Yes, it does help with taxes, right? Yes. Seeing last year, we got married. Well, and you guys, so me and Crafton got married on December 28th for this. So for the sake of the federal government, that means we were married all year long, except for we weren't. So I have always had a business that things like YouTube, or, because even just being on YouTube on his channel, I would get things like tips going into my PayPal. And that's where that went. If I did independent contracting in any sort of way, that's where it went, right? He never did that. No shock to anybody, I'm sure. Hello, Sarah. That's also what makes me hesitant. All right. Well, it depends. So speak your truth. It's rare. I mean, if it makes you feel any better. So what are we on, you guys? Like, it's like 3 years now since I joined up over on Crafton's, right? Because once he moved here, it went from, I just want you in the room with me, right? So that I can see if you laugh at my jokes, to suddenly he wants to come sit at the table so that they can hear me better when I say things rather than being in the background. It sounds like we're doing it. To suddenly I have my own microphone. To suddenly I get the good microphone that's louder. To suddenly, let's go on camera. You be on camera with me. But it's a camera that's like shooting the back of his head and coming at my face. It's like I got roped into it. But 3 years, and I mean, it's never happened with me, but that doesn't mean that I have open legal things in a different way. So far, so good, Auntie. Crafton's working today, so it's just me and Aiden, but we had fun. I was saying earlier he was looking for, there was some special edition album that came out today. So I spent my morning driving to 4 different record stores across our area. 2 hours worth of driving in total. He didn't find it. But it was fun. It's still, right? So for those that don't know, my son's in college. He's his first year in college, and he's special needs. So it was very hard for me. I melted down when he left. So whenever he's here. So I kind of like, actually, the fact I'm like, I'm still needed for something. And he got a girlfriend. So it's like, now I'm just mom, So anytime he needs me for something, I'm happy with that. Let's see. That's okay. That's okay, Rose. No, it's going to be quick. I just have to address G-dubs, and I had to strike someone yesterday and talk about it. Love you. Say hi to Mom for us, and I hope she's continuing to get better. Yeah, she's super polarizing. Yeah. That makes me feel better to know, Sarah. Because I'm like, I do. Okay, so I do feel like, because of course we're getting close to the end of the first year now, and I do feel like it has gotten a little easier. But I know when he was, I guess spring break was better than winter too. I was like, when he came back for winter break, I got used to having him here again, and then it almost felt like dealing with it all over again when he went back. It didn't last as long, but it's like, I had such a hard time when he first left. So I'm glad it's getting a little better there. Did get your emails? Did they come to my direct email, or did they go to Crafton? So it'd be the RK tip line one, the Gmail one, or the staff at the Mediocratics one. Because I want to say no, but I can check my own. I don't go into my own email very often. It's crap. Missed your comment. Scroll up. Let's say. Oh, it's funny. Oh, it's you. Well, there you go. So thank you. So I'm going to give you can I give you my opinion? Thank you. So I'm glad you did that, because it could have drug out for so long. Clearly she was never going to go. So thank you from me, because I think that is what needed to happen. I couldn't believe that. So did you hear, by the way, in that ruling, like, she's saying all that to you, and at least the way the judge worded it in his order, he was like saying, like, within the same time frame, she had emailed him with this like lengthy argument about when she's already supposed to be there, right? She's really already supposed to be in that jurisdiction. It's scheduled for that day. She waits till the day of to email him, but essentially they attributed that message to the same time frame. So while she's telling you, like, I'm never going ever, then she's telling him all the legal reasons why it's unfair. But I'm like, yeah, that did it, you guys. I know, Care D. I know. I heard her talking the other day about it, and I'm like, oh. Well, but does that matter? See, okay. So Aiden's college, right? He didn't go away, like, far away, but he chose to be on campus, and thankfully the university, had like a slow process. We got to go for the summer, get used to it, so I'm glad that they are set up and have a system in place for, people that are differently able to be able to experience those same things and accommodations and all that. But him being just 20 minutes away has not helped anything for me, because he doesn't want to see me during the week, right? He's busy with girlfriend, and he's going to classes and whatever, and I'm just mom now. Where's Sofa? I'm not sure. Yes, I think that you are correct. I think that you are correct. And you know what else it showed? Super arrogance. Arrogance. And I think that it stopped what would have otherwise been this horrible, drawn-out process where, I believe every word that I believe that she never, ever was going to actually accept what had happened. Ever. It was just going to be this drawn-out shit. Yeah, Outlander, he's doing really good, though. There's Sofa, whoever just asked. Yes, we love all her high IQ. So I'm going to keep calling you Nina since that's your screen name. Did you watch on civil laws different things along the way? There was one he did like 5 months ago where he was and just in general, even the first one he ever did, he focused a lot on reading through Kay's shit that she would put in herself, right? And his reactions were brilliant. I love it. Yeah, no, it's the girlfriend. Honestly, Outlander, when he got the girlfriend, and I love her, by the way, she's a great girl, and I hope they stay together because I don't want to deal with the first heartbreak thing. But and I like her, you know what I mean. Aiden's my only, so I don't have girls, and I enjoy hanging out with her. She comes home on the weekends sometimes. Do you all have each other blocked? Sofa, email the. Okay, hold on. Sofa, I have a message from Speak the Truth. Sofa emailed those voice clips. ... I need to hear you. End voicemail. Okay, flip-flopper's overused. Okay, here's the thing. This is my opinion. Okay, sometimes you become privy to new information, or your experience with a person gets you to a place where maybe things that were just quirky or that you maybe didn't necessarily love about the person or whatever starts to become a pattern or a red flag, and you will then adjust. Some things reveal themselves to us along the way. People can call that flip-flopping, and it's like, so maybe we back off and we're pissed off for a bit or whatever the case may be, and then maybe in the larger scheme of life there comes a point where we're like, that wasn't as big of a deal as I thought it was in the moment, or it isn't a big deal to me now, or someone whatever the case may be. That people can call that flip-flopping. I call that life. You know what I mean? I'm more concerned about people who have an idea and never ever change from it. Oh, yay, people remember each other. Sofa's awesome. We love our sofa. And yes, what a wasted opportunity. I mean, she could have done what she wanted and get a court to declare self-depletion while proving her case. It would have actually helped the people. Ray is abusing. Yeah. So, and again, saying that I don't know a lot about all that part of it. Okay. So that wasn't a case that I ever got super into. So it's basic research on Ray, because I knew I had heard, because it was more the legal part. I mean, this is when it became interesting to me. Okay. Is when it was okay. And not that I don't get interested when just in YouTubers in general, because you guys we are not considered under the law reporters. You have to get to a certain place maybe, and you can start to make that argument. But I mean, you're going to look at the Alex Jones case. There's precedent setting cases along the way where we just have to understand that YouTube is looked at more as another social media platform. The more people you reach, the more it can be used against you in a defamation case. And in the end, we do not get the privileges generally under the law as members of the press, even though some people might run their channels that way. Now, I would argue whether Kay necessarily ran her channel that way or not, but it's something, it would have at least been an argument to make. I don't know. But if Ray was abusing the legal system, yeah, I think fighting her case could have at least put her in a position to help if there were frivolous suits before. Oh, you guys are getting cloned. I'm so sorry. It's drama. Yeah. Well, he knows that always. He knows that always. There we go. See? So when people call any of us flip-floppers, just be like, I'm going to steal Sofa's saying right there. I'm like, just had to test drive all of you guys in order to find the ones that were tolerable. It's deep. Sabrina, you're always deep. I flip-flop on people in my own life. I have friends since I was an infant, but sometimes our friendship is close, sometimes not. Yes, it is. It's like an ebb and flow, right? It's just seasons of life, seasons of friendship. You got some good voice clips out of you. That's me too, Sugar Beat. That's why if there's like a egregiously like cringe, it's how I end up with people of the same nature behind me, Okay. In my opinion, Ray's a vile person. I agree with that. She won't ever stop. Okay. Whatever. We know what you meant. Yeah, so that's, and it sounds like it. If she's using the legal system to sort of weaponize things, but that's interesting. That's interesting to me too, by the way, you guys, because what I've noticed is nobody says she's a psychologist, she's a psychiatrist, she's a mental health counselor. They don't say any of that. They say she's a mental health provider. I've always wondered that. Do any of you guys know, since I know there's people now who kind of have, some knowledge of the case? Because I guess if you work in a mental hospital and you're an orderly, technically you could be called like a mental health provider, or a mental health care worker or whatever. It seems like they've always been very different about that. And I'm like, if you've got like a okay attitude like that, I don't know if you should be, you know, because I guess the way they word it, even though it's vague, it conjures up this image to me like she is working one-on-one with like patients or clients. Maybe if she's a social worker, I don't know. I know. Well, I bet you that the sofa cartoon will show up in Lycan's Patreon, I think. Thank you, Outlander. Sarah, I can't feel bad for her. She had all the support in the world, but she really used manipulation and intimidation to treat the people trying to help her like poop. Is that about Kay, Sabrina? Because, okay, so I mean, you guys, so again, here's the disclaimer for the people that weren't at the front end of this. So Crafton's channel took off very quickly, okay? So he had this channel, his channel, our main channel, Crafton and Kim. He had that for a while, and just, you know, tinkered with it, you know, music here, music there, you know, little things here and there. When he started to cover like parody, it was more parody comedy content around true crime, as weird as that sounds. If you know my husband, that's makes sense to you. When he started doing that, he had got up to like 300 subs and he was thrilled with himself. Okay. And that's when I met him, was when he started to grow a little bit from there, but he only got to, you know, he still wasn't even at monetization. I think he was like at 600, something like that, when he made me a mod. And he was talking a lot about Kim Kaufman. When he put out Lana's Shazam videos, that's when, I mean, it was just without warning, like, you know, and I think he was like up to 3,000 by the end of a month. I mean, it was just that quick that we had to kind of make all that stuff happen. But in the meantime, he had moved here, right? So it was like so fast that I had to kind of orient myself to here. But that's when Kay had reached out to him, because he was kind of, you know, he was someone everyone wanted to talk to at that point. And we were friendly, cordial, like in the, you know, creator to creator sort of sense, you know, for a couple months, and then we had issues. And then we had issues. So it's like, truly, guys, like, I have opinions on her. I'm not overly sharing them, but I'm just wondering, because if that's about Kay, she did reach, yeah. So she reached out to me when this first happened, but yeah. I can teach the law anywhere I want to, but I can't give specific legal advice. But more importantly, I don't know if I didn't know if I want to touch it with a 10-foot pole, but it did come across very, and I know from her and Crafton's interactions just about things, you know, in the true crime, you know, sector that they were talking over, you know, she didn't take advice very well. Yes. Do you remember that, Sabrina? A lot of people don't remember that. I don't sub to many channels, but one of the few that I do, she was just enamored with Crafton's channel. Hello, Steel Snickers. How are you doing, dear? We miss you. Yes. Okay. Okay. So she's in nursing. Okay. That's interesting. We are doing good. No, good with you. Good. Okay. Yes, that I was asking about Ray. Because for some reason, Sabrina, you know, and just kind of finding out like her litigation history or whatever, it kept, you know, one of the main points in this too was this sort of, it came up about the sort of malpractice that doesn't exist that was being implied by certain of Kay's comments. And I'm like, well, what the hell does she do? Because wouldn't they just call her what she does? But they never do. They say mental health practitioner. And I'm like, okay, well, that can mean, you know, so I guess now I know she's in nursing. That makes perfect sense. But then I saw another one, mental healthcare worker. And I'm like, to me, that conjures like that could be anything, right? Like I said, that could be like an orderly in a mental ward. You know what I mean? Could be anything. So no, that's helpful to know. So, okay. So I can see how that could factor in then. I think that was the weakest, but that's what I mean. They had a lot of weak ass arguments, you guys. Weak ass arguments. They're flat out calling her, like talking about her doing bribery. So that's accusing her of something illegal. That could have maybe gotten somewhere. I know Kay got boisterous about like her intentionally like inebriating people in order to do X, Y, or Z. But then again, we're talking about defamation, which means at some point, and here's where I'm going to agree with you, Sabrina. So based on what I'm hearing you guys say about this, at some point, and listen, defamation suits, you guys, even if you get sued, right here, if you want to justify why you have to spend your money on a lawyer or whatever, what you can always remember is especially if you're over here on YouTube, what's beneficial there is the discovery. Not only do you have to participate in it, sure, but you also get to ask for shit. She could have gotten somewhere with that. Hi, honey. All right, so you guys, it's like an Earth Day concert. So he's like, oh, great, it's gonna be a bunch of hippies on bongos. And for those that don't know, my husband's a sound engineer, so he works concerts and shows and venues and stuff for bands and all that jazz. But I'm like, she could have gotten discovery that could have been helpful in that situation. You know what I mean? And in the end, it's the person that's saying, hey, you're defaming me. Like it or not, it is a situation where you're the one who has to prove that the other person's lying. And so I would say this, in addition to what Sabrina said about this being a lost opportunity, because of other people that were maybe being abused by the fact that Ray was abusing the legal system and using it, I'm assuming it's kind of to intimidate and dissuade people from talking to her just for, uncouth reasons. The other thing that was lost in that is it's like, in the end, Ray was the one who was going to have to prove that all that shit was false to get anywhere. But that's what sucks. It's like they didn't even make it that far. It's just this is an interesting and unique situation. Okay, well, okay, interesting. So at this point in time, then she probably wouldn't. That means no patience, which might be why they get vague with it. Because I'm sorry, that's it's bizarre. I don't know why, you guys. Again, I have ADD, so yes, thank you. I can see the hearts, so they actually show up in the chat on my end. Can other people see it when people do that? It's hearts. She had every report on this case. Okay. So, Nina, do you think she had any big ol' information? So my impression reading it was that she didn't. She didn't, because there would have come a point like they wanted to settle. And I just know from talking to her in literally when I said the very beginning, you guys, I mean like the first, like, I think 3 weeks after that it came. And then that's when we had falling out, if you want to put it that way. Okay. She really didn't. Okay. Yeah. That's what makes sense to me then too. Yeah. I wouldn't think that it just stuck out like a sore thumb to me. I'm like, well, why wouldn't you do that? Like if they're willing to like drop it, there's going to be some NDA. It means you can't go back and talk about the Andriaco case again, but get it off your plate. If you found out something interviewing someone, just fucking give it to them and don't risk your money, because I know she has children, I know college is a thing. Like, I get all that. So thank you. Thank you, Stale Snickers. 1,000 hearts back to you, even though I can't put hearts in my own chat, or I could, just not 1,000. I think my character limit's 200. All right, guys. Yeah, hold on. Let me see what Sabrina had to say here. Rose says, hi, Crafton. I don't know if he's listening. He probably is just looking at his screen. Oh, wait. Yeah, here we go. Can't hear over band sound check, but I agree with it. Yes, that's a good husband right there, you guys. Happy wife. He's like, whatever she's saying, she's right. Okay, honey. Her Oh, whoa, hold on. TT, let's get some tea. Her son went on J for Justice and proved she had just, wow, okay. Mm-hmm. Yes. Yeah, she would have proved it. Yeah, she would have to prove it. I mean, it's like at this point, too, by the way, you guys, we are in a post Johnny Depp Amber Heard trial situation. So we all are a little more knowledgeable about defamation just in general. Now, this was like different. Okay. This is federal court, but, we all kind of have a better understanding than we went in with. Anymore. And it could have been a great opportunity. I mean, seriously, and especially for like a YouTuber. There's content that could have been had there. There really was. If she was gonna, if she was gonna fight it. What blows my mind though is the fact that she had access. Not only did she have access to low cost legal services, but this is gonna be my opinion coming out here, but that she was dumb enough to actually somehow overlook that sending proof of that to the court was not going to work out for her in the end. You can't keep making arguments about because I'm pro se and I'm disadvantaged by this, and this. This is so bad. This is, and then for some reason you in the middle of your shit put in there that like, oh hey, by the way, I did have access to low cost legal services, but oh hey, nobody ever called me back. It really looked dismissive of the whole process. Well, thank you, YT. It's good to see you. I hope you're having a good weekend. It is going to be, so soon enough, it's going to be moving. It's going to be here for a little while. We have rebranded the other channel. Right now, it's just called Kim and Crafton, as opposed to Crafton and Kim. Crafton did that on a whim the other day and just decided to announce it. It's because there was a lot of things that were being tagged over on Unmurdered, and Heather and Miranda are retired and they are living the YouTube free life, and we are so happy for them. But it's like, the channel's all switched over and stuff like that now, and I'm going to be moving the legal stuff over there, and I'm going to do it more frequently. So, and then we'll keep the other one over here for all the little Krama stuff and keep it separate, because it is hard for people that come over here for the legal discussions, and then they listen to me get ratchet on a bitch, and they're like, wow, this isn't what I signed up for. It's time to separate it out a little bit, Thank you so much, Stale Snickers. That's a tongue twister, isn't it? Yes. It'll be nice though to do that. But and you know what? But it's like the other part is that I wanna honor the people that's because the channel itself, you guys, was built up. Heather has people that have followed her for a very long time. And so that's like a true crime content. I think it's better to, I personally am not overly interested in true crime per se. I am interested in legal things. And so often it's going to overlap sometimes, but I feel like that's a better way to, kind of honor the people that have been with that channel for a long time. I am so happy for them too. So happy for them. Yes. So it's nice because now when the trolls come out to play, that it's very clear now who they're dealing with. So I've just been hide happy so far. Anybody, I'm like, you get one good shot to troll over there and then you're gone. So it's been great. All right, everybody. Well, thank you for tuning in. Like I said, I might give myself a little bit of time. I'll see where Aiden's out with stuff. I will be hitting live at some point tonight because I want to address Jessica Lynn claiming she was at the hearing yesterday. And of course, I heard from the sheriff's department since then. So I got an update there. And then I want to talk about a copyright strike that I had to issue last night. And we'll discuss about people that were using the Lycan end of that to steal my content, and just sort of reaffirm, since Crafton's channel's been off for a while, I just want to make a generic statement again about how, people don't read descriptions, but there's a whole legal disclaimer in there that says, if you use my content, you're going to have legal issues. Thank you guys. Yes. Well, it was Andrea's mom. I'll just put it out there. So if you're interested in that, look for the notification later. So love you guys. Have a good rest of your weekend if I don't see you around. And I will talk to you later.
Love the chase and the hunt, and I set the pace when I'm running. I always take what I want and I always give it 100. Don't need a bank, no I'm funded. Play the game like it's nothing. I'm always thankful for something. Don't take for granted, stay humble. Now wake up! It's time to look at the enemy. Look in the mirror if he is no friend to me. It's not working out, maybe it's the chemistry. It's time to break up so I can make a better me. Better believe in your mind, cause it's everything. You can mold, shape, find almost anything. All it takes is some time and some clarity to find your identity. It's mind over everything. And when I feel like this, I'm immortal. 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 Don't stop, just stop it up, don't and if you get in my way, you're gonna feel the wrath. Gotta say it to my face while he's looking back. Mirror breaks after math. When I hate, I attack. And when I feel like this, I'm immortal. When I feel like this, I'm immortal. When I